Good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our bi-weekly community conference call where we try to answer your immigration questions as best as we can. Note that the disclaimers and the caveats you heard when you were logging into the conference apply. That said, I'm going to go over the frequently asked questions first. There is 2 or 3 of them, not too many today. I designate certain questions as frequently asked questions because they are frequently asked. That said, let's do the frequently asked questions first, then any follow-ups on those frequently asked questions, then regular questions, and after that, if time permits, and new questions. First is from Deep SM 2003. This question deals with portability for an international manager or executive green card. So as you folks probably know, that after your I-485, employment-based I-485 has been filed and pending for 180 days, counting your I-140 approval. So the way this works is, the 180 days is the magic number. Once your I-140 is approved, we look back at the date of your 485 filing, and if it's over 180 days, you can join any employer with same or similar job. Now, this same or similar job provision, it also applies to international managers and executives. So that means if you were working for one group of companies, your 485 under EB1C was filed, and I-140 is approved, 485 has been pending 180 days, you can actually move outside that group of companies to a totally unrelated company. Whether it has any international footprint or not, it doesn't really matter. So in other words, AC21 portability applies to all categories EB2, EB3, and EB1C. Now EB1A is an exception because it doesn't require a job, so portability is not even needed. But just in case that ever comes up, remember that EB1 is also covered by AC21 portability. The question that we have before us is, we have an L1A, I-140 is approved in April, waiting for 485 approval under EB1C category. So that means I-140 was approved in April. I'm assuming that 485 was already filed, and if it was, and it has been pending over 180 days, your interview occurred, you went, and the officer said everything looks good. Now, the approval will come when the dates become current. So the 3 questions that are posed are as follows. Can I make a job switch? Are there any consequences? And the answer is, your interview is already over. This interview is a relatively new bird for employment-based cases. Earlier, there used to be no interviews for employment-based cases as a matter of routine. They were the exception rather than the rule. So would this necessitate another interview? I doubt that very much. So if you were to change, other than the implication of the interview having been done and gone, there's nothing else I can see, and I don't think the interview will be done again. So if you are qualified, going over to a same or similar job under the AC21 portability is perfectly legitimate, easy thing to do. If the old company withdraws your petition, which is your second case, a second question, it has no impact. Once you are covered by AC21 portability, whether you are under EB1, EB2, EB3 category, you are good. Do I require to submit AC21? Yes, you will be required to submit a supplement J that covers and shows the government how you are going to a same or similar job after 180 days of 485. *5. Press *5 on your phone if you have a follow-up question. No new questions. Any follow-up question on this? Okay. There is one. All right. Let's go to California. Okay. Yeah, California, go ahead. I can hear you.
Hello, Mr. Rajiv. Thank you so much. I'm Deep. This is the question that I posted.
Yes, sir.
Yeah, thank you so much for all the explanation. That makes sense. Yeah,
Of
so
course.
I understand that the fact of the AC21. However, the question that I have is one of the follow-up question is that do I need to? I have already submitted the 485J, and that has already gone through, and my dates are going to be current in February. Um, um, when I switch to any different company, do I need to proactively provide 485J or AC21, or I can just wait for the approval?
Uh, if you change jobs before your 485 is approved, supplement J must be filed.
I see.
Okay.
Okay.
All right.
Okay.
Any
Sure.
anything
So I
else?
need to submit another 485J from the new employer.
Yes, sir. Supplement J itself is the justification for AC21. So yes, you will need to file a supplement J if you move jobs before the green card approval.
I see.
All right.
Okay. Okay. Thank you so much.
You're
Yeah.
welcome. Good luck.
Thank you.
You're welcome. Okay, so now let's go on to the next frequently asked question, which is this has also come up quite a bit. What is the advantage of EB2 over EB3 category? In the old days, about a year back, there used to be an advantage because EB2 category, which is master's degree or EB or bachelor's plus 5 years experience jobs, used to move a lot faster. But the situation has reversed itself. Now EB3 is moving a lot faster. So, what is the advantage now of doing EB2 over EB3? I think it is still beneficial for a couple of reasons. If your job is better described as an EB2 job, you should not restrict your filing to EB3. Because remember, an EB2 case can be filed as an EB3 case, but vice versa is not possible. Let me explain. So let's say you filed your perm requiring either a master's degree or bachelor's plus 5 years experience. You got the perm approval. Now it is your choice when you file the I-140 whether you want to file as an EB2 or an EB3. So if your perm is approved under EB2, your I-140 can be filed as EB2 or EB3. You have a choice. But if you file your perm as an EB3, then you have no choice but to go with EB3. So first advantage and perhaps the only advantage of EB2 filing is that you have a choice. You can go from one to the other category, but not from the other to the one. So you can go from EB2 to EB3 if you so choose at the I-140 stage, but you can't go from EB3 to EB2 if that's what your perm was approved for. So choices, that's the number one thing. And number two, as I described to you, you have to describe your job accurately. You can't downplay or exaggerate the job. These papers are filed under penalty of perjury. So if the future job is supposed to be an EB2 job, you should file it as an EB2. That's what the law would require. Let's see if your questions are covered under this. Manju Rao says, I have just started green card process with employer A for EB3 category. My questions are, can I change category of same green card to EB2 when I join the employer B provided employer A is not cancelled? And there's a fundamental misunderstanding reflected in your questions. Are you on the phone? Press star 5 if you're on the phone. Press star 5 if you're on the phone. Press star 5. Okay, you're not on the phone. So I'm not sure exactly where you are headed with this question because there are many permutation combinations of your situation. Normally, when you change employers before 485 has been pending 180 days, you will have to start green card all over again from the perm stage. You can choose to go for EB2 or EB3. You are not bound to a prior case. So if a previous case was approved under EB2, you can file the second case under EB2 or EB3. If the previous case was under EB3 and you qualify for EB2, again you have a choice, file as EB2 or EB3. So really you're not bound to the previous case. You asked me what are the advantages of EB2 over EB3. I just discussed that. Currently filing I-140 process is in progress with employer A. In case I join employer B before I-140 approval, Can I start I-140 with employer B in parallel? No. You still have to go through the perm process with employer B. If the perm was approved, sure, you could do more than one I-140 in parallel. But you cannot do an I-140 skipping the perm unless you qualify under national interest waiver or EB1 categories. So either national interest waiver or EB1. I hope that answers your questions. Star 5 if you have a follow-up question on this. Star 5. Okay. Let's go on to the next frequently asked question. So this is a question that comes up also relatively frequently. Oh, I think I messed up this frequently asked question header. Mira wanted to know what is the difference between final action dates and dates for filing. So let me explain to you real quickly what the dichotomy here is. Visa Bulletin used to carry all the dates. Then the government realized, well, people who are filing I-485, they might be able to file it earlier because of certain computations. So the government a few months ago started publishing separate dates for people who are in the United States and are filing I-485. You might be able to do an earlier filing, which became the dates for filing, which are available at the USCIS website. Although they've said February on this year, they're not going to publish different dates, at least for a while, I guess. But the difference then is that the final action dates are in the Visa Bulletin. Dates for filing are at the USCIS website, and they only apply to people who are in the United States, eligible for filing I-485 adjustment of status, and are in fact filing for I-485 adjustment of status. Okay. Star 5 if you have a follow-up question. Star 5. All right. I think those are all the frequently asked questions. Now let's get into the non-frequently asked questions. The first one is from Ayush, who says, I'm on H-1B, 6 years will complete in June this year. Approved I-140, currently in Houston. Okay, one of the issues that you are raising is about what happens when a green card has been filed for location X and you are moved to location Y. Most lawyers that I know who understand immigration law will always file through the corporate headquarters of a company where a job is capable of being transferred and relocated. So let's say we have IBM who's headquartered in Houston, Texas, but an employee is working in Alexandria, Virginia with a job that is project-based and maybe transferred from place to place. In such a case, even though you are currently working in Virginia, we will file your green card through Houston, indicating that your job is subject to transfers and relocations. That's the proper way to do these filings. Therefore, even when you are sent from place to place to place to place, you don't have to refile your green card every time you do that. So I'm not sure how or why your green card was planned in a manner where it was filed through a location other than your headquarters. Government has indicated, Department of Labor has indicated, corporate headquarters is the proper location for these kinds of jobs. So let's go back to your questions. You are in discussions to move your job location to Dallas. Should we file H-1B extension and amendment at the same time, or is it better to file extension first and then amendment? I don't see any reason to separate the two. I don't think it's a problem to file both together. And if you think that you incur some additional danger, that in case the extension and amendment are denied, you'll have to leave USA, that's not true. So I don't see any problem with that. I can't understand or think of a single instance where clubbing extension and amendment together would create greater risk for you, if you are indeed moving. Now, if you're not moving and the job remains the same, then there's no point in filing an amendment. Is there any issue to request extension and amendment for Dallas location based on an I-140 for Houston? Not at all. Your I-140 can be approved for a completely different location because it is a future job, whereas your present job is governed by your H-1B. So the example I gave that IBM is located in headquarters in Houston, Texas, that's where your green card was filed, but you're working in Virginia, your H-1B has to be filed for Virginia. That's your present job. Your employer's attorney says that they need to file the PERM process and I-140 once you move to Dulles. I guess they have not filed through the corporate headquarters. Now remember, there are two ways you do not have to file a green card, two ways, and depends upon your case. Obviously, you have not filed through your corporate headquarters, so the question of being protected by the relocation doesn't arise. I'm not sure why they did that, but whatever that is, I'm assuming they did not file it as a relocation clause possible. Now, if they move you, your green card could still go on if you intend to be relocated back to Houston where your green card was filed. So let's take the example I gave. It's easy to remember. Corporate headquarters is in Houston. We filed the green card through Houston, even though you are working in Virginia. Okay. If we had not filed through Houston, if we had filed through, let's say, Virginia location, and then we moved you to Massachusetts, can the green card still go on? And the answer is yes, if upon approval of the green card, we want to move you back to Virginia, the location for which your green card was approved. So in your case, if your green card was approved for Houston location, and upon approval of the green card, you will be moved back to Houston, you can actually continue that green card without filing a new one. So a future intention to return to the location. Interestingly, once that intent is established, your dates become current, you file 485, and 485 is pending 180 days. You can actually be moved to any location and you can even choose to stay where you are. Okay, I hope that's clear. And your question number 4 is directly connected to what I've been discussing. Your green card should always be filed through corporate headquarters. That's why no matter how many times you are moved, you never, ever, ever have to file a green card again. *5 if you have a follow-up question on this. *5. Okay, I guess you folks are going to listen to the recording. Let's go on to the next one. Booger says, I'm a green card holder since August 2014. Got married in July 2017. Marriage was in Europe. Wife has been to the US twice on tourist visa. First time she stayed 3 months, second time only 2 weeks. In August 2017, I filed I-130. I received a notice of action that was the receipt with the priority date of 2017. I haven't received any notification that my application has been approved. So what should I do? I think the first thing to do is to open a service request. You go to the customer service number, you call them and say, I want to find out what is happening to my case. So if you have received any kind of an RFE that it was not delivered to you or something, that should become clear. So that's the first thing I would do if I were you. I would go ahead and make a call to the customer service. That's what I would do. And that would tell you what the next steps are. *5 if you have a follow-up question. *5. Okay. So let's go on to Bhaskar 2020. Priority date is September 2016 EB2. I-140 was approved. It has been significantly more than 180 days since the I-140 has stayed approved. Okay, he was with the same employer for many years. H-1B extension is good till 2020. I want to change employment. I understand that I'll be able to port my priority date as well as the right to keep extending my H-1B. Very good. You already know as much law as I do in this area at least. Employer B would have to restart by green card processing. Yes, that is also true. A couple of questions relative to this. For employer B to get me on board, they would have to file an H-1B transfer. Correct. Upon approval, would the validity of that H-1 be the same as my current extension? It should be. That's what we hope. Or will it be 3 years from the approval of the H-1B transfer? See, what the government has done is they've been a very inconsistent set of approvals. Sometimes they do it, sometimes they don't. I can't tell you that they are going to give you 3 years from the date you filed the transfer. They should. Your employer is paying for it. That's what we hope for, but I can't guarantee that's the way it's going to be. Do I need to have an approved I-140 from employer B for H-1B extension? Of course not. Of course not. Once 180 days have gone by, even if the I-140 is revoked, it is still good for extensions through any employer. Can I keep getting H-1B extensions with B, C, D based upon my approved I-140 with A? Absolutely. Yes, you can. Star 5 if you have a follow-up question on this. Star 5 if you have a follow-up question. Okay. Rupraj. Currently on EAD, priority date June 2009, I-140 EB2. Form was filed with computer programmer analyst with a very broad job description. Once I got my EAD, I made use of AC. Oh, there is a follow-up question. Folks, you got to be a little bit quicker. Star 5 is not hard to find on your phone. So please, that way we don't keep going back to the same case. So this is Georgia. Let's go to Georgia. Yeah, Georgia, go ahead. What is your question?
Apologies for the slight delay there.
That's fine.
This is Bhaskar who posted the question.
Yes.
Understand all your responses. Thank you and appreciate all your effort. I just have a quick follow-up on my question there. So do I understand correct that employer B or C or D can file a H-1 extension using a I-140 that was approved by employer A? So the petitioner for the approved I-140 is different, and the petitioner for the H-1 extension is different, and USCIS accepts that. Is that correct?
That is correct. Yes, sir.
Okay.
Good luck.
Perfect. Thank you. Thanks
You're
a lot.
welcome. Yeah. Good luck. Okay. So going back to, where was I? Rupraj. Oh, yes. So the job title for the perm was Computer Programmer Analyst, broad job description, EAD, did AC-21 portability, joined a position as a senior software engineer. Now the lawyers are saying these jobs are not same or similar. I am surprised. First of all, the job of a computer programmer analyst and a job of a software engineer are very, very difficult to distinguish. Anybody who understands technology should know that there is very slight difference. A software engineer does everything that a programmer analyst does. The only additional task they do is software design. So software design, software engineering, that's the additional job duty. Otherwise, they do the coding, they do the systems analysis, requirement gathering, documentation, quality assurance. All of those are rolled into these two jobs. There's barely any difference. These are same or similar jobs. Okay. So now, unless they use some job description which is completely off the left field, which makes no sense, I don't see why these jobs would not be same or similar. Your questions are, is there any way to mitigate the risks while filing Supplement J? I think, well, first of all, you can't make up things. Whatever the truth is, you have to tell. You should ask for a second opinion, talk with your company's lawyers, see what they suggest. I would be surprised if the two jobs are not same or similar. There is a lot of leeway in technology positions. I think you should be fine, but have it double checked. If USCIS rejects Supplement J, can I go back to my approved I-140 and continue working with my current employer? The answer is yes. So if a Supplement J for a portability is denied, even though you have joined the next employer, you can go back to the past employer. That is quite clear. Star 5 if you have a follow-up question. Press star 5 on your phone if you have a follow-up question. Okay. Yeah, you're going to be fine. I don't know what they are thinking. Maybe I haven't seen the cases, so I really can't comment authoritatively. Okay. Folks, you got to be a little quicker in pressing your star 5. Okay, let's see. We have a hand up from Massachusetts. I'm not doing any new questions right now. If you have a new question, let me see. Yes, go ahead, sir. What is your question?
Hey, Rajiv, this is Rupraj.
Go ahead, Rupraj.
Yeah, so, it was just a 3-point that was a little bit different on my form and the job description from the new company. So when I just cross-checked with my lawyer, immigration attorney, he said, they don't match because of these 3 points, but he said, he can make a strong case, but there is no guarantee that.
Okay, hang on 1 second. Let me back you up a little bit. First of all, okay. Nobody can guarantee anything in law. Anybody who guarantees things is naive or a knave, one of the two. Okay. So nobody can guarantee. But just because 3 points are different out of a 10-point job or an 8-point job or a 15-point job, it doesn't mean these jobs are not same or similar. Remember, the jobs are not required to be same. The expression is same or similar. Similar means there are some differences. That's just English. That's not even law. Okay?
Okay. Got it.
Anything else?
No, I think that's all from my side. Thanks, Rajiv.
Good luck, sir. Okay, let's go on to the next one. Yeah, same or similar by their terms mean there are some differences. Excuse me. Let's go on to the next question. This is from RichML9987. I'm the principal applicant, India born, I-140 approved, EB2 category. Priority date 2014. Fiancé Nepal born, getting married. She's in India. I'm not working for employer AA, that's the future employer. Okay. But I don't know what's going on with my I-140. So, is it possible to get I-485 filed under Nepal quota? You have 2 sets of questions. So, first question is, can I file for cross-chargeability when my fiancé is Nepal born? And the answer is yes, definitely, once you get married. The second question is a little different. So, I have an I-140 approved through first employer. I go on to the second employer. Now I want to file 485 through the first employer. The only way you can do that is if you intend to go back to the first employer upon approval of your green card and they are willing to extend to you the same job offer. Okay, so theoretically possible, practically maybe not. What do they need to do? They need to extend a good faith, honest job offer to you that they will hire you back either now or upon approval of your green card. You just need them probably once, or if there is any questions raised by the government. This is more than just an offer letter. I think you should discuss it with your lawyers. I always worry about these cases as to the genuineness of people's intention. If you intended to stay with this employer, why did you leave them? After all, you were working with them earlier. So there are some issues, although they have not come up, but I worry about them because they are common sense issues. Star 5 if you have a follow-up question. I've answered your questions. Star 5. Press star 5 if you have a follow-up question. You do not. Okay. Then we've done this frequently asked question. Then from New Andhra, currently working on EB2 485 EAD, AC21 for B company, and I do not have an active H1B. I'm current in EB3. Can I downgrade from EB2 to EB3? Yes. Last conference call 2 weeks ago, we discussed this under the frequently asked questions in great detail. Please listen to that. And I've discussed that several times over the last few months. So you can just listen to the frequently asked questions portions. Read them and listen to the recordings. I'm not working with this company. That doesn't matter. Do I need to start from the labor cert? No, you just submit the I-140. And you can submit I-140 and 485 together if the dates are correct. I don't see why not. Should my current EB2 EAD be intact? Can I work with the original employer even if I file EB3? That doesn't make any sense. Oh, I see. You already have a pending 485. In such a case, you don't have to file a 485 again. All you have to do is file an I-140. Once it gets approved, make a request to the USCIS to use that I-140 to adjudicate your pending 485. I've discussed this also the last time around. Okay, listen to the last 2 weeks ago recording, which was I think on the 10th, January 10th, 2 weeks ago. And yes, your EB2 EAD will remain intact. So get your I-140 filed for EB3. Once approved, make a request that government should use your EB3 I-140 to approve your 485. So you don't have to refile the I-485. Star 5 if you have a follow-up question. Star 5. Press star 5 if you have a follow-up question. Okay. So this one is from an anonymous caller. I'm assuming that that's a voice over IP phone. So let's see. Go ahead with your follow-up questions, please.
Yeah, Rajiv, this is Neandra. So I can work with the EB2 EAD, right?
Of course.
I don't need to submit H1B.
Of course.
I don't have an H1B actually.
Yeah, no problem.
Okay.
No problem. Okay. Is that it?
Yeah, thank you.
Oh, you're welcome. Good luck, sir.
Yeah, thank you.
Okay. So then we go on to the next, which is Rash003, working on H1B I-140 approved. Oh, planning to start a new business. Yeah, I have discussed this in great detail several times. I think even on my LinkedIn profile in the articles, I have an article that describes this. It's definitely there on immigration.com under our frequently asked questions. And I'll just do a real quick summary. I won't go into the details. The way I see it, I can't say that this is the law, but this is my interpretation of the law. An H-1B holder can be a passive investor. So for example, if you wanted to put money in the stock market, nobody can stop you. So what is the difference between a stock market and investing in a small business? As long as you're not involved in the business. I would say the safest thing is to have as much distance from that business as you would have if you invested in stocks of IBM. So if you went to the Wall Street and you bought stock in the IBM, you don't get to pull up a chair in the IBM headquarters and say, hey, I own 2 stocks of IBM, now I'll run the company. So as long as there is a large distance between investment and control, or investment or actual operation of the business, I think it's okay. That's my guess. And I don't think it should affect your H1 or your green card as long as it is passive. Star 5 if you have a follow-up question. Star 5 if you have a follow-up question. Okay. Let's go on to Rick wants to know, how does it work if I change from a non-profit to profit employer after either priority date or I-140 approved? I don't see any reason for you to think twice about it. Unless you are in some kind of a special category like a national interest waiver and there are some components of it that are implicated. Typically, if you are a POM-based application, it makes zero difference. Can I switch to a for-profit employer soon after the date, and what are the consequences? There are no consequences for POM-based cases. Can I switch to a for-profit employer soon after my I-140 approval? Again, no consequences. Can I change my job roles? As long as you redo your green card, which you have to, you can go from one to the other with complete indifference to their profit or non-profit status. If my wife also is on my I-140, will she be also getting green card the same time as me? Does she need to start her own green card? No. If she's your derivative, she gets the green card same times as you do. And if you have a choice, always file for both husband and wife separately, so that if something goes wrong, one to the other, you can be derivative of your wife. So if she wants to file a second one, a green card independently, it's a good idea because it gives you added protection. *5 if you have a follow-up question. *5. Okay. Rick had a second question. My wife applied for H-1B last April. Case is still pending. Timelines. Nobody really knows. Just follow up through your congressman's office if it's taking too long. *5. No, I guess Rick is not here. So then the next question is from AV H-1B. Approved H-1B from employer valid until June 2020. After 6 months working with them, I transferred to employer B. Approved for 1 year till April 2019. Worked with them for 9 months. Transferred to employer C. Started working for employer C with receipt number. Okay. H-1B transfer petition to C from B has been denied. Employer B has revoked my H-1B while employer A has not revoked my H-1B. See, my guess is that you can go back to employer A as long as they still have that job. Have your lawyers review the regulations. There were some changes made, and I think it's under HCFR 214.2. There were some changes made in January 2017, which say that in a situation like this, it doesn't say exactly like this because you have one extra employer in between, but I don't see any reason legally why you cannot go back to employer A. Your I-94 validity date, I would say, is all the way to 2020 if you still have that job open. Employer A is willing to take me back using the 60-day grace period by filing an amendment. I don't think you need an amendment if you have the same job available. But if the jobs are different, then of course you have to do an amendment. Some random employer X is also willing to file H-1B. That's a difficult one to answer. Let's see. Because your I-94 is valid till at least April 2019. So you are covered by the 60-day grace period. I don't see why not. I think it's the same chances whether through employer X or employer A. If I go to employer A, work for him for a couple of months, then transfer to employer X, will this allow employer X to transfer my H-1B? Sure. Sure. Absolutely. Is this the safest route? Look, your lawyers should assess that for you. They should review the regulations. I'm giving you a snap judgment based upon what I remember of the law and what I see in your facts. I think they're the same thing. I don't think there's a difference. If you're covered by the 60-day grace period, filing directly through that. Although, come to think of it, if you get a denial, then you might have an issue going back to employer A. So maybe it is a little safer to go to employer A and you don't have to wait for a couple of pay stubs. You can just have employer X also file an H-1B for you. If employer X's H-1B is denied, you still have the employer A. What if the amendment with employer A gets denied? Will the original H-1B still remain valid? Yes, as long as the original job is available. So that's really the key issue. *5 if you have a follow-up question. *5. Okay. Let's see. This is from North Carolina. Okay. Yeah, North Carolina, go ahead, please. I can hear you.
Hi, Rajesh. Thanks for the response.
Of course.
So since I do not know how long is my I-94 valid, whether it is for April 2019 or July 2020, in case if the amendment petition with employer A gets denied after 6 months, let's say July 2019. At that time, though my original H-1B petition is still intact, do I assume that the original job is still available?
No,
Can I
that's
say-
not, you're putting the cart before the horse. Let me explain to you what I mean. So let's say your employer A, your original employer, had a project in Raleigh, North Carolina, working with the state government. And that's where you were working. Okay. Now, let's say you left them and you went, and now you want to come back. If they can put you back on the same project with the same job description, everything the same, you're fine. Your I-94 is good till 2020. But if that job is gone and they're trying to relocate you to, let's say, San Francisco with another project, they have to file an amendment. In that case, if the amendment is denied, does your I-94 time get truncated? I don't think so. But normally what the government will do, when they deny your case, they will also say you're now accruing unlawful presence. So really, I think you would then be covered by the 60-day grace period if at that point your case gets denied. I'm trying to juggle a lot of regulations in my head because your case is quite unique. I would have to spend some time thinking about it. Think about all these issues that I'm bringing up and bring them up with your lawyers when you file your case. I think you are protected no matter what happens, as long as the old employer has not revoked, employer A has not revoked your case, and even better, if they have the old project for which you were approved still going on.
Right, Rajeevji. So they don't have the old project, but they found a new project and they are filing an amendment using the 60-day grace period.
I think then I would argue that you're only good for 60 days. Your I-94 is not valid. Again, it's a lot of different things playing around my head. I would go with 60-day grace period as long as the case is pending. You are not out of status and you're not unlawfully present. So while the amendment is still pending, you decide to jump ship again, you can do that. That's a bridge petition pending. You can do that. I don't see any problem with that. Does that make sense?
Yes, sir. So assuming my 94 is valid as of now, as per the last action update, let's say April 2019, if I move to employer X from employer A after a month, will this employer A's amendment petition still act as a bridge petition?
Yes, I believe so. I believe it will. So the worst case scenario is if the employer's A's H-1B gets denied, government could potentially argue that, hey, we're not going to give you status within USA. When we approve employer X's case, you have to go outside, get visa stamping done. That's the worst case scenario as I see it.
Oh, sir, if I go with employer X on premium and if I leave employer A's amendment in regular, what are the complications I see here?
Look, I'm going beyond my scope of what I can do for you here. These are good issues. You should bring them up with your lawyers who do the H-1B filing. One thing you have to keep in mind, there is no premium processing right now, except in very limited circumstances. It might return in February. We think it will. But until then, talking about premium processing doesn't make much sense. Okay?
Okay. Yeah.
Good luck to you, sir.
Big question, sir.
Yeah.
Yeah,
I think you have the right idea. You're covering all the right questions. Just sit with your lawyers and go over them one by one. Okay. Good luck, sir. Yeah, folks, we are a little bit constrained in time. A couple of minutes we can discuss things, but we may not have time for an in-depth discussion. But I think when somebody is hitting all the right notes, I know that they can talk with their lawyers and make sure those issues are covered. Just like we discussed, I think all the important things are covered. Chanel, who is Jane's SJ, says, my H-1B extension plus amendment case was filed on April 12th. It's still pending. They're not accepting premium. We cannot upgrade the case. 240-day work authorization expired. Now, you see, again, I have to look at the regulations to give you an exact answer. But the way I see it, there are two kinds of permissions to continue working while a case is pending. One is the 240-day, which is an extension filed with the same employer. But if you file an extension with an amendment, Could you argue that you're covered by a different law, which is AC-21? I think you can, and that allows you to continue working indefinitely while the case is pending. So I would have to look at the regulation, but I think as long as you also revisit this issue with your lawyers and make sure that they have checked and briefed you about you being covered by AC-21, which allows you to work indefinitely, great, you're good to go. I don't know off the top of my head. I would have to look at the regulation, but I suspect that's the way it would work out for you. Okay? So I think you'll be fine. Just have them double check it. *5 if you have a follow-up question. *5. All right. So from Mr. Gupta, Parthasen Gupta, EB1C green card is in process. Priority date is May 2017. I-140 is approved. EAD advanced parole combo is available. 485 interviews scheduled for mid-Feb. I never filed 485 supplement J. I'm getting it ready. What is the significance of supplement J? Well, supplement J is a substitution of an offer of employment. So remember how we used to file in the old days, a year ago when we filed any 485, we gave an offer of employment, a letter. Now we give supplement J. I can't help you fill the forms, but because if I help you fill the forms, then I have to sign the forms. What I can tell you is that normally supplement J is required if you are changing employers or if you are filing I-140 and 485 at different times. So those are the typical cases, portability, etc. Is there any risk in getting the green card if I quit my job subsequent to my interview? And the answer is, I think it's much better for you to file AC-21 portability. We discussed that as a part of the first question, where we were discussing AC-21 portability today for EB1C, international managers and executives. I think you must file a portability, AC-21 portability supplement J, if you're going to quit and join another employer before your case is approved. Can you sit at home and do nothing? I wouldn't advise it. I think there are some legal issues there that require you to continue working till you get your green card and after. *5 if you have a follow-up question. *5. Okay. Folks, I have 13 minutes, 1-3. Let's see what we can handle. Press *5 on your phone if you have any question. I'll only be able to take the questions that I can in the 13 minutes I do have. Okay, so we'll do the best we can. Right now we have only 3 raised hands. That means about 3 or 4 minutes each. Okay, I'm going to start in the order. Well, there are a lot more hands up now. I can only get whatever I can get in the 13 minutes that we have. I have appointments scheduled after that. Let me start with Texas. In the order that you logged in, whoever logged in first, I'm getting to them. Texas, go ahead. I can hear you.
Yes. Hi, Rajesh sir. This is Milind, and actually recently I got a noise notice from USCIS on my H-1B petition. My master's was done from for-profit university.
Yeah.
I graduated.
Let me stop you there. So if you went under quota,
yeah,
and your university was not covered for quota, you're out of luck. You should be filing an H-1B under the quota in April. Okay.
Yes. So since I have right now I-94 valid till end of this April, can I still go under the quota?
Yeah, you will file under the quota.
I don't need to wait.
Yeah, you will file under the quota, but once they revoke or deny your case, you have to leave USA and wait outside for the result of the lottery. Okay.
Yes, agree on that. And what happens with my I-140, which is already approved?
That stays untouched. That has no issue at all.
So my I-140 still stays. It doesn't matter. My H-1B was approved under error from USCIS.
I don't see any problem.
But that doesn't harm.
Yeah, that's not a problem. The only issue is just talk with your lawyers make sure that the company has the ability to pay wages even if you are not on their payroll. Okay. I can't discuss the issue in detail. I've got other people waiting, but have your lawyers look at the ability to pay wages if you're not on their payroll. Otherwise, I see no issue at all. Okay? Good luck. Okay. Yeah, guys, I'm going to try to get as many people as I can. This one is an anonymous call, so I don't know who you are, but you are probably from on a voice over IP. Go ahead, please. Voice over IP, go ahead.
Yeah, Rajiv, this is Nuyandra. Again, I just have one question, follow-up question with regards to the EAD, that is EB2 or EB3 reporting.
Okay.
So, do I need to submit the supplement J form even though if I go back to my old employer, original employer?
I believe you do. Yes, sir. Okay.
Okay.
Good luck.
Yeah. Okay. Thank you.
Bye-bye. And also remember, guys, I always look for the practical solutions. I'm not an academic. My job is to find practical solutions. The way I look at it, what is the harm in filing? Right? It's not costing you. Well, it doesn't cost any filing fees. The lawyers may charge you a little extra. Okay, let's go to South Carolina. South Carolina, go ahead, please. South Carolina.
Hello, Rajiji. Good morning. My name is Kumar.
Yes, sir.
I have a quick question. My job with my current employer recently ended, so I'm on H1B with them, and then they have filed my I-140 with a priority date of 2014. So I think now I have 60-day grace period to find another employer and apply for my H1. So I'm also thinking that to apply for H4 because my wife is also on H1. So I just wanted to know, like, what the complications are like if I go on H4.
I think that's a very good idea. Okay. You have everything to gain, not much to lose. Again, I don't have the time to cover all the details and why I think that, but suffices to say that please file your H4 before your current job expires. Let it remain pending. File your H1 as soon as you can. Inform the lawyers that do the H1 that you have an H4 pending. The pending H4 gives you great amount of security. Please file it. Okay?
Okay.
No harm in doing that. There's only benefit, no harm. Okay?
Okay, great.
Good luck.
Thank you, Rajesh.
You're welcome. Okay, now 2 more questions. The next one is this one is also from Georgia. Yeah, Georgia, go ahead, please. Georgia, I can hear you.
Hello, Rajiv. I have a quick question. So currently, my employer is holding the original I-140. I have a copy of that, electronic copy of that. Should I be requesting my lawyer and or employer to, have the original I-140?
I've never filed an original I-140 ever in any application. So I-140 approval notice copy should be more than enough. Okay?
Okay.
Good luck.
Okay, thank you.
You're welcome.
Yep.
Okay, the last question for the day comes from Illinois. Okay, Illinois, go ahead, please. I can hear you.
Hello, Rajiv, sir.
Yes, ma'am.
My H1B is currently in transfer state, and it's been more than 6 months now. I would like to know, if I'm on medical leave, how will my employer handle it?
Okay, well, that's a relatively easy question. Although we've discussed it in our past frequently asked questions many times, I'll give you a quick summary. If I may ask you, is this a maternity-related issue or some other health issue?
Some other health issue.
Okay. Now, I've had a case where somebody was out of work for almost, I think it was almost a year and a half, maybe even 2 years on an H1B, but we were able to still restore status to H4 because their health issue was quite serious. So remember, if you have a medical reason not to be working, it is perfectly okay for you not to work as long as you can justify it. Now, you said you have an extension, or is it a transfer pending?
It's a transfer pending.
Okay, now remember also that when a transfer is pending, there is no obligation to work. You have the right to work, but you have no obligation to work. So you don't even need a medical excuse. So let's say there are 2 dates involved. Date 1 is the date you quit the first employer, and date 2 is the date you filed your transfer. As long as date 2, the date you filed your transfer, is before you quit the first employer, you don't have to have any excuse not to work.
For me, it is after I quit the first employer, I got the I did the transfer.
That could be a major complication. You could be accruing unlawful presence, because if you quit the employer and go ahead.
But I have my I-140 and my visa date are still valid.
That doesn't matter. That doesn't matter. What I want you to do is, you could have a complication. I'm not saying you do. You could have a complication. This is something a lawyer should look at. Please speak with the lawyers who filed your H-1B. Discuss your case with them. Find out exactly what they recommend. Okay? This is an issue that needs to be examined.
Even if it's okay, it's because there were 2 transfers that happened, so that's why I had this
might
question.
Protect you. That might protect you because you have a bridge petition pending. That might protect you, and I think it would. I don't want to worry you, but I don't want you to not discuss it with somebody. Even get a second opinion if necessary. But do talk with your lawyers, okay?
Okay, and you're saying the problem might come only if there is an RFE or any other proofs that I need to submit, or even when the...
I really don't have the time to discuss in detail. I've got about 4 minutes. I can try to cover some basic aspects of it. So I go fast, but this call is being recorded. You can listen to it later. Here's how it works.
Okay.
So let's say you've got 3 employers in the picture. Employer 1, Employer 2, Employer 3. 3 employers in the picture. Okay. So you were working for Employer 1. You filed a transfer with Employer 2, correct?
Yes.
Okay. Now, when you filed that transfer, you were still working for Employer 1. Your H-1B was still valid, correct?
No.
Had you stopped working?
There was a break. There was a break.
What does that mean? What do you mean by break?
So I quit the first employer. I had a 20 days break, and then I went to the second employer where the transfer happened.
Was your I-94 still valid?
Yes.
Okay. Again, this is not something I can cover in this this brief consultation. You need to talk with your lawyers. I think you're covered by the 60-day grace period. You filed another case. So that means you have a bridge petition filed. While that case was pending, you filed a third case, correct?
Yes.
Okay. So I think you're being protected, but it is important for somebody to take a look at your facts, because the smallest difference in facts can change things. However, going back to your original question about the medical leave, remember, when you have transfers pending, there is no obligation to work. You can sit back and not do anything. It's only when you get an approval and you cannot work, you will need a medical necessity letter. Before that, there is no issue. Okay. So while the transfer is pending, you have the right but not the obligation to work. It is okay for you not to work. Okay?
Okay.
Good luck to you. Good luck.
Thank you.
Bye-bye. All right, folks, as always, I really always enjoy talking with you. I will see you again in 2 weeks, and I appreciate the opportunity to serve the community. Talk to you guys soon. Take care. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.